I've titled this lecture, Everything You Wanted to Know About 28 U.S.C. Section 1782, but we're afraid to ask. Of course, that title is extremely presumptuous because it assumes that everything that the imagination can fashion somehow will be addressed. Far from it. So the point here is for you to feel free to write, call, contact me any way you can or want so that we can have a follow-up. Moreover, this is going to be the first of a two-part lecture on Section 1782. As most of you are aware, the Supreme Court just recently came down with I call it the fund case, but it's really ZF Automotive versus Luxshare. I call it the fund case because that is the cases were consolidated. Two cases were consolidated. The first case, the ZF Automotive, is the international commercial arbitration piece of the decision. The second case, the fund case, is an investor-state arbitration arising out of the Russia-Lithuania bilateral investment treaty, where Russian investors filed the action. That's basically the configuration. We're not going to get into that case today. Important as that case is, the whole objective of today is to find ourselves in a situation where we can really address that case, address the fund case, address the Supreme Court's most recent pronouncement, and second, only the second case since Intel in 2004 where the Supreme Court actually addresses 1782. So the point is to try to understand how we get to the Supreme Court, and then understand the fund case, the Supreme Court's recent case, beyond just black letter. Because, as I will suggest to you right now and throughout the course of today's talk, I do not believe that it's going to end with a complete evisceration of 1782 in the international arbitration sphere, treaty-based or contractual. I don't believe so. And even as things stand today, without any type of legislative amendment or evolution of the doctrine, I believe that there are three ways in which international arbitration, both treaty-based and commercial, will be able to find that 1782 is extremely helpful and relevant. I will not tell you how it works, not today, but I will say this. It's bookended and in the middle, so there's perfect symmetry. The way it's going to work is at the very beginning of the case, at the very end of the case, and in the middle of the case. There will be three salient opportunities for 1782 activity based on the state of affairs today with the doctrine, with the fund case, with the Supreme Court saying that an arbitral tribunal is not a foreign or international tribunal for purposes of 1782. With that having said, let me just first of all say that today we are going to do more than just get into a how-to 1782 approach. I don't think that works, and I believe that it is necessary to canvass the doctrinal development of 1782 so that we can really have practical skill in the application of 1782, so that we can really fashion existing arguments as best as possible and come up with new, better arguments depending on the factual matrix of the case before us. So instead of doing a how-to, we're going to do a doctrinal development with some emphasis on the how-to portion. We're not going to totally avoid, evade, or downplay the practical applications, the practical workings of 1782. Before we get into the subject matter, I do need to thank a number of people or acknowledge a number of people who have influenced my thinking with respect to Section 1782. First, one of my old civil procedure professors, the late Professor Hans Smith, which of course is so relevant in the Supreme Court decisions on the subject and really all commentary on 1782. He was the great authority, will always be the great authority in some significant way. And his thinking has shaped my view of 1782, even today, even with the Fund case, the Supreme Court's recent pronouncement. The second person I'd like to thank is Professor Linda Silberman of NYU, also Professor Franco Ferrari of NYU, Professor Jack Coe of Pepperdine, and of course my law partner Ryan Reeds, who has as much practical experience with 1782 as anyone on planet Earth, and also is a superior theoretician with respect to the doctrine. Let's get to work. The way we have to think about 1782, I believe now, is pursuant to three fundamental paradigms. The first paradigm that we saw with respect to the very narrow issue of when a tribunal constitutes a foreign or international tribunal for purposes of 1782 is adjudication. The first paradigm was a paradigm of adjudication, meaning that the tribunal was dissected, analyzed, looked up and down throughout with a microscope, and the adjudicative functions of the tribunal, we thought, based on the first generation of case law and doctrine, would define whether the tribunal was, or the court, or the adjudicative body, if you will, was a foreign or international tribunal for purposes of 1782. So the first paradigm we thought was adjudication. The second paradigm that started to appear was a morphing, a leading behind the adjudicative faculties of the purported tribunal, and really a focus on whether that tribunal was the product, the offspring of governmental or intergovernmental regulatory action. Was that tribunal created? Was it a governmental tribunal? Was it an intergovernmental tribunal? Did nations get together and create this tribunal? Is this tribunal a national tribunal that arises from the exercise of national sovereignty? We thought that there was a movement away from adjudication to the origins of the tribunal. Now, with the case, with the Fund case, with the most recent pronouncement, it seems to be a little bit different. Still, the third paradigm. This third paradigm appears to say that the real question is whether A, the tribunal is a governmental or intergovernmental tribunal, but then B, whether that tribunal somehow was imbued with, to use the court's language, with governmental or intergovernmental authority. So now it's not just the characteristics of taking evidence, of hearing testimony, of issuing a decision, of serving as a lower court for higher courts or higher second instance review. Now it's no longer what is the genesis of the tribunal. Is it governmental or is it international or intergovernmental? Now it's governmental, intergovernmental, and imbued with either governmental or intergovernmental authority. So we have a third paradigm which seems to be a synthesis of the first two, but as I will suggest to you eventually, I don't think it is. I think it's something else. I think it's actually a fourth thing, that a fourth paradigm, a fourth paragon, a fourth matrix that rests on two very specific, untested assumptions that I believe will form the basis for legislative activity and maybe perhaps even more judicial activity on 1782. So with that being the basic roadmap of where we're ultimately heading, let's look at first things first. First of all, one thing that we have to do in starting with any analysis of 1782 is, what is 1782? Guys, what is 1782? And what is not 1782? What is it that 1782 is not? And I have found that on this very basic point, which is extremely consequential on existing issues and issues yet to be brought before second instance tribunals, but that it inevitably will and will identify those. I find that there isn't a clear view that people are not understanding 1782, its actual nature. And the only way that I think we can really understand the nature of 1782 is by focusing on the foundational rules of civil procedure that would help us understand what is 1782. And you know, the first rule of civil procedure that I want to bring to your attention, which no one reads, is Federal Rule of Civil Procedure 2. And Rule of Civil Procedure 2 says something that's very, very simple. It says that a civil action is, I'm sorry, no, it says that there will be one form of action. There will be one form of action which will be a civil action. So there's only one type of action. It's a civil action. And then Federal Rule of Civil Procedure 3 says that a civil action commences with the filing of a complaint. So a civil action commences with the filing of a complaint, and there's only one type of action, which is a civil action. What is 1782? Is 1782 a subpoena? No, it's not. It's like a subpoena, but no, it's not a subpoena. What 1782 technically is, we find out really when we think of the second federal rule, the third federal rule, and then Federal Rule of Civil Procedure 7. Federal Rule of Civil Procedure 7 identifies a pleading. And you know, I don't want to get into the actual wording of it, but it says something like a pleading is either a complaint, an answer, a counterclaim, a third-party complaint, a cross-claim, a reply to a claim, or a petition, an interpleader, something like that. So it's basically a pleading that seeks either an affirmative claim, which can be in the form of compensatory damages or injunctive relief, of course, and that can be mandatory or prohibitive injunctive relief, and the corresponding writing that addresses this pleading, or in addressing this pleading also seeks affirmative relief. And then the rule tells us that everything else that is not a pleading is a paper. And this is very important because this helps us understand a number of critical things with respect to 1782. Something as basic as, for example, when you do a conflict check, how do you structure that conflict check like a case? Is it a claim that you're bringing against someone? Is there a plaintiff and a defendant? No, of course not. There's no plaintiff and there's no defendant. You can't structure it like that. So it'll have a similar application in the conflicts area as would a subpoena on a third party or non-party. So that's one application that's important. One aspect of this that's important, but a second aspect of it that is extremely important is the fact that it's not a plenary case. And because it's not a plenary case, there will be jurisdictional issues having to do with general jurisdiction that will govern the issuance of a 1782 application, grant of a 1782 application, the standing of a 1782 application. I would just want to call it a jurisdictional basis for 1782, even though in some sense that's really what I'm talking about. So this is an extremely important issue. Also, because it's a paper, that also tells us that the applicable deadlines are different, right? You have to use the applicable deadlines for papers and not the applicable deadlines within the federal system that you would have for pleadings. And that's something that's also extremely important. And while we're on the topic of deadlines, how about this? Statute of limitations. So often we're caught up with, well, this happened a long time ago, or you know, we may be late on the 1782, all sorts of scenarios that one can conjure up, and us lawyers, we always come up with a lot of different ideas, so to speak. No, statute of limitations is not a concern. Again, it's a paper, it's not a civil action. So this is extremely important. Please keep this in mind. So we've talked about what it isn't, and we've talked a little bit about what it is from a formal procedural perspective. But from a substantive perspective, we also have to keep in mind what it purports to be. And what it purports to be is an instrument for assisting foreign or international tribunals and for assisting litigants before such tribunals. So let me first talk to you a little bit about some boring history on 1782 and on the taking of evidence generally in cross-border disputes, and then we're going to drill down a little bit more on this whole issue of what actually is 1782 substantively, if we can speak of it in substantive terms. What do its three core elements in the statute really mean, can mean, should mean, and how are they applied? And then, of course, how do the second instance courts, with emphasis on the Fourth and Sixth Circuit compared to the Second and Seventh Circuit, and within that rubric, of course, we're going to look at Servitronics 1, Servitronics versus Boeing, and then the second Servitronics, versus Rolls-Royce, and of course, we get different rulings by on the identical parties, virtually the identical parties, on the identical issue by the two separate circuit courts. Ultimately, this ends up being debated and analyzed by the Supreme Court in the Funk case. So let's start talking a little bit about what 1782 from a judicial assistance perspective, from an assistance of a foreign or international tribunal perspective, how it comes about, and you all may recall that 1782 in effect circumvents the international cooperation methodologies that historically were used to get evidence in the United States for purposes of using that evidence in a foreign, meaning non-U.S. proceeding. We first had, of course, and dealt with the cumbersome letters rogatory, which were plagued by a number of procedural, logistical challenges that were vastly improved, no doubt about that, by the Hague Convention on the taking of evidence abroad in civil and commercial matters, which we typically refer to as the Hague Evidence Convention. So this means that when we look at it in geometric terms, I guess, 1782 is the legal tantamount to a straight line representing the shortest and most direct path between 2 points when information is required from a person subject to the jurisdiction of the United States. This is extremely important because I predict and I share with you that this is going to be the second wave of uncertainty that will visit upon 1782, primarily in the context of post-Daimler, of course, which is where we are, issues on service of process, or in this case, an application directed to a corporation where the principal place of business of the corporation or the place of incorporation is not where the 1782 is targeting. This is an issue that I think will be a very, very interesting, robust, fulsome issue that we will have to deal with at some point, and this is the time to start thinking about it. So this is all critical, I think, information. So let's start with the plain and ordinary meaning of 28 U.S.C. Section 1782, and I think we really do have to look at the statute because there are aspects of the statute that I believe we overlook in terms of its structural significance. And one such issue that I want to bring to your attention right here, right now, concerns the very issue of the interested person, which we'll get to in just a second. I want you to think, at least consider, I'm not asking anyone here to adopt my view, but I ask you to please consider my view that the interested person component of 1782 is really a default provision, that it is a secondary provision. It is a provision that only is triggered where the actual adjudicative body, or now governmental/intergovernmental tribunal imbued with governmental or intergovernmental powers or authority, only when that tribunal itself is not requesting for the 1782 assistance. So there is the default provision of the statute has actually conquered the imaginations and the actual practical working of lawyers and the actual practical workings of the statute. The default provision has become the most important provision. And I say this and I raise it because, again, we're working towards trying to understand the Supreme Court's most recent pronouncement. And if we're going to try to understand the Supreme Court's most recent pronouncement eventually, we have to understand that based upon the black letter law of that pronouncement as it now stands, there will be two universes of adjudicators who will never be able to access 1782. The core of 1782, forget about the default provision, what I call the default provision, and these are the arbitrators in international commercial and investor state arbitrations. They will be foreclosed from using 1782, and I'm not interested in the empirical data of how many have thus far or how relevant that may be. Conceptually, it's extremely relevant, notwithstanding whatever empirical arguments can be made, one way or the other. So I say that to you as we now canvass the actual body of the statute and look at it with some care. And forgive me for reading the statute, but I must. It says 1782, paren A, quote, "The district court of the district in which a person resides or is found may order him to give his testimony or statement or to produce a document or other thing for use in a proceeding in a foreign or international tribunal." We're going to look very closely at resides or is found. We're going to look at that language very closely, but we're also going to look very closely at the word may, because the word may is critical. It doesn't say shall, and that has a practical consequence, of course. And then we're also going to look at some language here that is also typically ignored, which is testimony or statement, or to produce a document or other thing. Stop there. We're also going to look at whether, in fact, that textual language narrows what you can do with the Federal Rules of Civil Procedure in the context of discovery. Then, of course, the thrust of our analysis will circle on foreign or international tribunal, and then we go on, including criminal investigations conducted before formal accusation, a very, very powerful part of the statute. Before formal accusations, you can still use 1782, or upon the application of any interested person. Now let's stop there. Here's what I mean. You see that the first part, before you reach the disjunctive or, it's the tribunal that takes the initiative. And now with the disjunctive or, all of a sudden, the parties are the drivers. So let's keep that in mind, and let's keep it in mind in the context of what I said is a preclusive type of effect for a whole universe of adjudicators, arising from the Supreme Court's most recent ruling on the subject, Justice Barrett's opinion, which is a unanimous opinion by the court. So let's continue with the statute. Or upon the application of any interested person, and may direct that the testimony or statement be given, or the document or other thing be produced before a person appointed by the court. The order may again prescribe the practice and procedure which may be in whole or part the practice and procedure of the foreign country or the international tribunal. Let's stop there. This is another part of the statute that is always somehow overlooked because we're so concerned with the federal rules portion of the statute. But from a how-to perspective, if you find that the tribunal may not be a friendly tribunal for 1782, may have concerns during the course of argument with, well, is this imperialist law? Is this the imposition of the federal rules of civil procedure on another court, which conceptually it cannot be given the way that the statute really works, but the argument has been made. You can argue, well, no, in fact, we can agree on a procedure that works in conjunction with the rules of procedure in France or in Tanzania or wherever the case may be. It's an alternative. It's another argument that is out there and that can be used and that often is ignored or altogether just excluded, quite frankly. But you could also tell how that argument dovetails with the thinking that the statute really has the primary intent and motive of having the drivers of the arbitration, or in the case of international arbitration, or of the tribunal or of the proceeding, the adjudicators, the decision makers, really take the lead. It goes on, to the extent that the order does not prescribe otherwise, so that's, notice the way it's written, to the extent that, again, a default provision, to the extent that the order does not prescribe otherwise, the testimony or statement shall be taken and the document or other thing produced in accordance with the federal rules of civil procedure. Now, this is interesting because notice that it doesn't say discovery under the federal rules of civil procedure. And there are ways of reading a lot into this. There are ways of keeping it more sane, despite a number of textual arguments that can be made. I like to read it expansively. When it says the federal rules of civil procedure, it means all the rules of civil procedure. And in the context of discovery, I will bring to your attention that I believe this means more than just documents and things and statements, and I'll get into that in just a little bit. And of course, it ends by, the statute does, it ends with the language, a person may not be compelled to give his testimony or statement or to produce a document or other thing in violation of any legally applicable privilege. So it has this protection language that I think is of course, extremely important. It's not really necessary given the importance of the principle, but it's nice to know that it is in the statute and in the most recent iteration of it, of course. Here again, it is important to know that unless otherwise stated in the order that the federal district court is to issue on the matter, the federal rules of civil procedure apply. And there are two important principles that I'd like to bring to your attention. First, I think the applicant should state in the application that the applicant wants the entire panoply of the federal rules of civil procedure to apply. It should not be restrictive. Secondly, a question you always, I'm sure, wanted to ask, but were afraid to do so, is whether only documents or things, testimony and statements can be secured through 1782. After all, the textual language of the statute only mentions these three items. I think it may help to consider that there certainly is a textual, ordinary and plain meaning analysis in support of a broader access to discovery methodologies. And what do I really mean by this? I'm talking about Federal Rule of Civil Procedure 33 interrogatories, which some may very loosely contend is a statement, but it really isn't. It's interrogatories. And you're saying, well, gee, I mean, why would I want the interrogatories? Well, you know, for the same reasons you may want them in litigation. And there are, for example, damages contexts where those interrogatories can be extremely helpful, particularly when you know that you can test the legal and factual sufficiency of what's being said with the upcoming deposition scheduled afterwards. So the interrogatories should not be downplayed. And on complex matters, there's also the issue of whether requests for admissions, Rule 36, should play a part of 1782. My personal feeling and what I encourage you to think about, and again, I want everyone listening to this to think for themselves and draw their own conclusions, but at least consider this argument that when federal rules of civil procedure are referenced, it's not limited to discovery. And now you're saying, well, why are you saying that? Why are you saying that? Why are you saying that? Well, because there is authority out there that says, and commentaries that say that Federal Rule of Civil Procedure 36 requests for admissions are not part of discovery, that they're not part of discovery, that there's authority that says that Federal Rule of Civil Procedure 36 is really intended to limit the issues in the case. So I can see someone who is a proceduralist, a nut for detail, making the argument, wait a minute, you know, that's not contemplated by 1782, this is judicial assistance, it's obviously a reference to discovery within the context of the federal rules, why these requests for admission? Well, you may want to use requests for admissions for the very reason for being of requests for admissions, that they're helpful. Plus, of course, you have the added bonus of what happens when the request is not properly answered, and the consequences in terms of sanctions, fees, et cetera. So I want you to keep that in mind, and all this goes back to the textual language of saying Federal Rules of Civil Procedure means Federal Rules of Civil Procedure. You may want to think about this also in the context of the 11th Circuit Court of Appeals opinion in Highlands Inn versus Trinidad Tobago, and that's at 739. At second 536, it's a 1984 11th Circuit opinion. And that asserted that Congress deliberately amplified the statute's 1782 scope to include not only depositions and written interrogatories, but also the discretion to secure documents and other tangible evidence to permit federal district courts to assist proceedings in foreign tribunals without limiting the meaning of foreign tribunals within the statute to courts or exclusively judicial fora. 3, to permit interested persons and not just foreign tribunals, as is the case in less efficient proceedings pursuant to Hague Convention strictures, directly to petition a federal court, a federal district court for judicial assistance, and 4, to eliminate the requirement that the discovery process used to be applicable only while there is a pending proceeding, and that the document and information produced only be used by a foreign tribunal. Before going through the salient features of the plain meaning of the modern version of 1782, I do want to talk to you a little bit about the background of the legislation, which is important. Before doing that, however, I just want to synthesize where we are. Where we are is that we are contemplating understanding 1782 in a very fulsome sense, where you can get the full panoply of discovery plus anything else that the Federal Rules of Civil Procedure may offer in terms of conceptual judicial assistance, which is what the statute substantively, if you will, is about, this procedural statute. And this statute, which is functions within the framework of a paper within the Federal Rules of Civil Procedure and not a pleading, and that's where we are. Now, 1782, the statute of its history. Well, let's start by saying that the statute is old. It can be traced back to 1855. And, you know, this legislative history, by the way, has more than just academic value. It has practical consequence and practical application. Again, how this history is read really can be tied to the Supreme Court's holding in the fund case and its reasoning in the fund case. You have access to the same legislative history, of course, that the advocates appearing before the Supreme Court had, and that the Supreme Court has and used. So you could judge yourself. So it dates back to 1855. Many of its core elements, however, started to appear and reappear as of the passage of the Act of March 3, 1863, which allowed U.S. courts to obtain testimony to assist foreign courts, but only if such testimony was for use in suits, for actions that pertained to the recovery of money or property, very limited subject matter, 2, that were pending in a foreign country with which the United States was at peace, and 3, in which the government of that country was a party or had an interest. So there we do see some governmental flavor, again, to borrow from the fund case, the language of the fund case. We do see some governmental flavor, but I suggest hardly enough to build anything solid on, conceptually. This 1863 statute, with its limitations, remained relatively intact until 1948. Beginning 1948, Congress enacted several amendments that broadened the scope of the statute. Let's stop there for a second. This movement in statutory development, I also believe, is extremely important and can be interpreted in many ways. But regardless of the light in which it is cast, one thing is inescapable. The movement of the statute is one towards liberalization and expansive use. It's not restrictive in nature. You will see that all of these shackles and qualifications start falling off. It doesn't have to be another government that's involved. That goes out the window, so to the extent that anyone thought that was meaningful, it wasn't implemented in subsequent legislation. The peace requirement between the United States and such government also goes away. The subject matter restriction on a debt or property, that goes away as well. And the judicial proceeding aspect also goes away. And the pending requirement of the action also goes away. Now, this is not an interpretation. These are just facts. This is the way it happened. So these facts, this trend, is an extremely interpretive vehicle, and it's something that, again, in the switching from the academic theoretical to the practical how-to, you want to keep it in your how-to toolbox, because you will need this argument. I assure you, you will need this argument at some point in time when you're before that tribunal, irrespective of which side you may find yourself on these issues. During this time, now we're looking at the 1948 amendment, however, Congress retained the requirement that the judicial proceeding be pending in a foreign country with which the United States was at peace. This will follow in a second. This qualification would not survive the next round of amendments, which took place in 1964. Then Congress enacted the most recent amendments to 1782, giving us the contemporary modern iteration of the statute. These modifications did mark a significant departure from Congress's extremely cautious approach to international judicial assistance. There was a philosophical change in terms of the role that U.S. courts and that U.S. rules of federal procedure would play in what was becoming increasingly an interactive, litigious world, even back then in 1964. Imagine with the advent of globalization in all of its phases. Congress adopted, without objection, a set of proposals submitted by the Commission on International Rules of Judicial Procedure that revised Section 1782. Let's stop here for a second. I believe that every practitioner who is involved with 1782 should have a copy of the report that ultimately ensued from this commission. That report is, again, it is rich with analysis and with historical data that you can use every day in practical arguments, and that you can also use in understanding what courts are doing with 1782. We will see as we continue our talk that this report that ultimately issued from the Commission on International Rules of Judicial Procedure, that report had the genesis of the intel factors that are now so famous and that we will, of course, visit. But then it also helps us because it does not have, for example, the functional approach test, which I personally refer to it as the dysfunctional approach test that the Second Circuit articulated, for example, in the Gould case, and which mercifully and thankfully was not adopted by the Supreme Court in the fund case. So this report, in many ways, serves as a litmus test on the origins of rules and standards that have to do with 1782. And again, I think you should also be mindful of the differences between rules and standards with respect to 1782 in your advocacy. Rules, of course, are bright lines. Standards are not bright lines, and there's a question as to the extent to which private or even public international law is best served with standards and not rules. I know some colleagues, and principally really Linda Silverman, who is thinking a lot and publishing on this issue. Exciting material. So the legislative history unambiguously demonstrates that the purpose, or at least one of the objectives underlying the proposal, was to engage other nations to follow the lead of the United States and to adjust their procedures in order to improve practices of international cooperation in litigation. Now, here we can be legal realists and ask ourselves, well, okay, that's laudable, but 1964 was a while ago, and I don't really see most countries on planet Earth rushing to adopt the federal rules of civil procedure. No, that's true. But let me just say that beyond that, one thing that I do agree with in terms of the recent Supreme Court fund case is that the animating principle of 1782 in many ways is comedy. And this is extremely important. And if we think about development, you will find, and you'll be surprised to learn that now a number of European countries have, for example, Germany, have versions of 1782. And I dare say that the United States was a good pioneer, a beneficial pioneer, a benign pioneer in causing this reality to take place. There's also a Swiss version, for example, of 1782. I've looked at them, and you can very plainly see that they are influenced by 1782, and the whole point is to expedite judicial assistance abroad, beyond those host states. And this is extremely exciting. It's powerful. And also on the how-to part of the ledger, it's something that helps you make an argument that what you're doing is not if you're an applicant, It's not just some idiosyncratic measure that is unique to the United States and that can be offensive to the court that you're purporting to assist. When you are looking at a situation where it's the default provision and it's the interested person who actually is initiating the initiative, the undertaking, I should say. Let's go back. There are a couple of things in the commission report that I think are important. Notably, the commission report explained that, quote, the word tribunal is used to make it clear that assistance is not confined to proceedings before conventional courts. In view of the constant growth of administrative and quasi-judicial proceedings all over the world, the necessity for obtaining evidence in the United States may be as impelling in proceedings before a foreign tribunal or quasi-judicial agency as in proceedings before conventional foreign courts. So here we do see, of course, the broadening, the expansive nature and movement of the statute. But I want to caution you, for purposes ultimately of analyzing the fund case where we're working towards, we have to keep in mind that the cutoff point for trying to understand this legislative history is 1964. The cutoff point for trying to understand intent in a normal, ordinary statutory interpretation analysis, which is, ordinary textual language, so it's text, context, legislative history, commentary, objective, and intent. When we look at those five pillars, of course, you want to make sure that it happens as of a date certain, so that if you look at an international arbitration today, you say, well, look, the claimant is from Sweden, the respondent is from France, the applicable law is German law, and the seat of arbitration is Bulgaria. How can that not be a foreign or international, certainly an international tribunal? What is there in that configuration that is national? Well, that's not the question. In fact, that has almost nothing to do with the issue. The issue is whether that configuration was contemplated in 1964 with this legislative history as being an international tribunal. That really is the question. And having reached this point, I think that this is a natural breaking point for what will be actually the first of three sessions on 1782. I will reschedule a second session on it, and I hope that this will help you a little bit, even though we have not finished. It's the beginning of something that will culminate with an analysis of the fund case. And again, please feel free to write, to call, and it would give me the most exquisite pleasure to engage in a dialogue with you on this subject. So having said that, thank you so much. Thank you for your time. Thank you for your undivided attention. Thank you.